Well said. Thank you very much. Okay, if you would state your name for the record, who you're with, and your position on the bill.
Yes, ma'am. My name is Kassi. I am speaking for myself, and I am against the bill. I'm an appellate attorney concerned about this issue. As a wife, mother, and pro-life Catholic, I too, frankly, have been scandalized by some of the prior Catholic testimonies. I've analyzed the law, including the most recent amendments by Representative King, and appreciate the opportunity to address it with you tonight. We've heard a lot about DNARs, and I will not discuss those at the moment. I did analyze that provision of the bill in my written testimony, which you've been provided. I would like to talk about patients' rights and the withdrawal of artificial nutrition and hydration under subsection E of 166046, because I don't think that's been entirely accurately presented tonight. Starting at the beginning, the fundamental problem with TADA, and not remedied by SB 303, is that life and death decisions are made for the patient. It should not be further enshrined in law. That a doctor can simply decide to withdraw care from a patient he is deemed futile, rather than simply say, it violates my conscience to continue care, here's a referral to another doctor, and treat until that person can be transferred either to another facility or another doctor. There is no reason for this process. A doctor's conscience can be adequately protected. A patient's rights can be adequately protected. One thing that I note is that we would never accept a law where a doctor could decide based on a diagnosis of a fetal abnormality that woman could not maintain that pregnancy. I would hope we are still at a point where I can say that. Why is this any different? Because it's at the end of life. This is no different. If you think about it in that context, this is no different. And so your decision should be quite clear. The convicted felon has more due process rights and a guarantee of a conflict of interest-free proceeding, multiple appeals, which might actually change the outcome of his guilty verdict, than the sick patient in a hospital who has been declared futile by his doctor. I don't think that this is what is good for Texas. I don't think it's right for patients. And I think we can do better. I think we must do better. And I do not think this bill can be amended enough to remedy these significant deficiencies, because they are at the heart of TADA itself. I do want to talk real briefly in my remaining 45 seconds. I want you to please look at my paper I handed you. If you look at page 4, starting with paragraph 16, I discuss in detail an analysis of where artificially administered nutrition and hydration may be withdrawn, even during the period of time, an extended period of time given by the court under subsection G. It can be withdrawn if the doctor, based on his reasonable medical judgment, has determined that one of those subjective broad exceptions applies. Those exceptions are so broad, almost anything can be worked into them. So while it appears to give you something with one hand, it takes it away with the other. There's no net gain for the benefit for the patient.
Thank you very much. Appreciate it. The chair calls Robert Stanton and Nelson Peel. Are you Mr. Stanton?
Yeah.
Okay, great. Do I